This is the Coppola Firm. I'm here with Jennifer Scharf, my partner, and Erin Ewell, our colleague. And our goal for the next 30 minutes, give or take, is to get you some practical, useful information about COVID-19 for your business. Granted, this is a quickly changing situation. We are keeping abreast of what's happening on the local, countywide, statewide, and national level, and we're all doing our best. I think that's one of the things that we as business owners and managers and principals need to keep in mind, perhaps giving ourselves a bit of grace as we're juggling our workforces, our businesses, and for many of us, our families as well. So kudos to you for taking this time this afternoon to join in trying to make sure you're educated and empowered as best you can be. A couple of housekeeping measures. As I said, we'd really appreciate if you could mute yourself. We have a component for those of you who are familiar with Zoom. You know that there's a chat box at the bottom of your screen. That's the place where you can type in questions, and we'll do our best to get to as many of your questions as we can. I love it. Jen Scharf just introduced everybody to the chat box by encouraging you to ask your questions there. While this webinar is not giving legal advice, our lawyer colleagues on the call know that. It is trying to educate and empower you. And to the extent we don't get to all of your questions, we will do that on the back end and make sure that we are answering them in our social media and our news events that we'll provide to everybody, of course, free of charge. As we've all started to say at the office, we're all in this together. And as you might see from the tiled images of Jen, Erin, and I, we are practicing social distancing. Our office is fully equipped to be distance and virtual. And while I'm here in the office, everybody else is working from home and continued to be connected well to technology. So we're going to get started here. I'm delighted, as I said, to see everyone here. And we're going to kick it off with some of the questions we've been hearing from clients and friends. So Erin, help us out. So if a business owner or manager sees an employee who comes to work and appears sick, well, what are they allowed to do under the law?
So without question, if you have an employee reporting to work who is showing symptoms of coronavirus, COVID-19, you have the absolute right to send that employee home, and we're encouraging employers to take that step as a precaution.
So what are employers looking for? So let's say, I have a small business, medium-sized business, or a large business. What am I looking for to protect everybody?
So we're not doctors, you know that, we're lawyers, but we have the guidance from our local health officials, from the CDC. The symptoms that we're encouraging employers to keep an eye out for are coughing, sneezing, definitely any employee who complains of a fever or claims to have a fever, shortness of breath or sore throat are the symptoms to be aware of. If you see those symptoms, we're, like I said, encouraging you to send those employees home. At this point, though, we do want employers to be mindful that our health officials are sharing concerns that many individuals who are able to spread coronavirus do not show any symptoms at this time.
Right. And so what should people who are running businesses, whether they own them or manage them, how should they and what should they be communicating to their workforce?
So I like to break this down into two important pieces that you should communicate to your staff. So the first one, and since we're talking about symptoms, we'll start with your paid sick leave policy. This one's going to be a little bit confusing because in the last 24 hours, New York State rolled out some legislation on paid sick leave that is available to employees. There are a lot of thresholds, so different requirements for different employers. It depends on your gross annual revenue. It also depends on how many employees you employed as of the first of the year. So I'm not going to jump into too much detail on that right now in this webinar, because we could probably spend an hour talking about all those nuances. But the takeaway I want everyone to know is there is a brand new law in New York State that gives employees paid time off, or at least job protected unpaid time off from work if they are subject to a quarantine order or an order of isolation from New York State or a state health official. So that's piece one. Communicate your existing paid sick time off, available sick time policies to your employees, and encourage them to stay home if they are sick. The second piece that you should be communicating is what are your business's expectations with respect to travel. So this applies to both personal travel at this point and work-related travel. Everyone should be putting out clear expectations. Is travel allowed? When is it allowed? Are there certain places that you're not allowing employees to travel? And we're certainly encouraging employers to limit travel as much as they are able to do so.
And employers can put into place policies, can't they, Erin, if an employee chooses on their own personal time to travel anywhere or someplace concerning, an employer can put into place an objective policy that requires them to self-quarantine, can't they?
They absolutely can. We recommend, if you'd like to take that approach, to develop an objective policy and apply it consistently across the board.
Right. Thank you. One of the things we wonder about, everybody's wondering about, right? If you're a business that can employ distance work, what do you have to do for the employees? Do you have to pay them? Do you pay them the same? What happens if they're hourly versus exempt or salaried employees? Talk to us about that, Erin.
So those are all great questions. And as you've already identified, it depends on the category of the employee. So I'm going to cautiously say right now, if you're requiring employees to stay home and they cannot work, you probably don't have to pay them. I say that with a big asterisk to take a look at that new legislation from New York State. Depending on the circumstance, depending on the size of your company, they might be entitled to paid leave. But there's a lot of questions there. So just be aware that that law might come into play. If you have an hourly employee who is actually able to perform work remotely, then you would pay that employee at their regular hourly rate while they are working from home. A great tip here is to find some sort of consistent way to have those employees record the hours that they are working. And then the last piece is for your salaried employees. To the extent that salaried employees are able to do their jobs remotely, not much changes for them. You don't really have to worry so much as recording hours, but getting those individuals set up for success so they can continue to keep your business moving while working at home.
Great.
Erin, I'm just seeing in the chat box that somebody posted a new order from Governor Cuomo imposing new requirements across New York State, saying that no business can have more than 50% of its workforce working outside of their homes. Essential services are exempt, and that includes food, healthcare, shipping, and supplies. But that's designed to slow the spread. So it seems that a lot of businesses are going to need to have people either telecommuting or not working on site.
Oh my goodness, and I'm reading that and it looks like that came out at just afternoon today. So I apologize, I was preparing for this, but it's a great sentiment that businesses need to have someone monitoring this legislation, because when I tell you things change by the day, if not the hour, that's absolutely true. So I haven't had a chance to review that yet, but I trust it's accurate. So.
Yep. So
that reminds me that we are also going to be offering you guys the opportunity to sign up for a mailing list from us to get answers to your questions and updates. So if you, at the end, we'll give you an opportunity to submit your email address, which we'll maintain confidential. We're not going to share it with anybody, but use it for updates on this topic.
So I just got a question in the chat box asking whether businesses are required to cover the extra costs an employee might have for working from home. And the examples this participant talked about were a DSL line, a computer, an additional phone line, things like that. And the answer to that question generally is, if you are right now, right? And we just saw from our friend Larry that there are news breaking events every 15 minutes, it seems like. But generally speaking, under New York and federal law, you have to equip your employees with the means to do their work. So we're talking about W-2 employees. We're not talking about independent contractors here. So generally speaking, if you're requiring an employee to work in a place that is other than their office or their location, you have to equip them to do their job. Now, might that change? Certainly in light of, the fast moving pace of this pandemic, we may see something come down the pike, and when and if we do, we'll certainly put that out in the releases that we're giving on COVID-19.
And I would jump in and say, and you may want to, right? You want to be able to control particularly security. So if you're providing the devices or providing the means, you're going to have a greater amount of control over the security that goes into them for your telecommuting employees.
Right. That's particularly important for those of us who, work in an environment where confidentiality is paramount. Many of the professional service providers I'm seeing as members here in this call have those obligations, whether you're accountants or you're in the fields of healthcare, mental health care, law, of course, and many others. You've got to, you as the licensed professional have the obligation to ensure those who work for you keep all of your materials confidential. Great point, Jen. Thank you.
We got another question in the chat box that relates to the order that just came down from Governor Cuomo about keeping 50% of your staff out. And the question is basically, can it be 50%, a different 50%? Can you keep your whole workforce working, but basically staggered shifts? And I think the answer to that is yes, you can. And you can be flexible with these policies. And you can put in, of course, temporary policies, which we'll talk about in a little bit, that address this time right now, so that we're not necessarily binding the company for a long term, but in this crisis, how we're going to address the workforce and to ensure that everybody gets to work. Staggered shifts are definitely something that can be considered. And we do have to remember about uniformly applying that, coming up with a system so that a particular group doesn't get a better or worse shift than another, and make sure that we apply that fairly. So that would be a policy that you want to consider, likely with legal counsel, how you're going to implement that.
Right. I got a private question here about, what if an employee who you want to come to work refuses to come to work? And, is that something that you could discipline the employee for? That question it's a difficult one, right? Because normally if an employee isn't, no show, no call, right? Discipline follows. Here, however, there are certain rules under the federal OSHA Act, Occupational Safety and Health. We think about that as governing, generally workplaces, but often plants and construction sites and things like that. But OSHA also applies here. And so if an employee can establish that he or she is in imminent danger, they have a right to stay off the work site, the office, the plant, wherever their work might be. And so we would guide you by saying, generally speaking, the usual rules won't necessarily apply during this crisis, but it's important to confer with, your trusted resource, whether it's your HR professionals in-house, your outside human resources consultants, or your counsel, before you take steps that might lead to liability for the company. So it's right, we're flipping the world on its ear right now. Normally, no call, no show, they might be out of a job. Here, it could be a little bit different. So guide yourself accordingly about that.
And strategically, you might not really want to discipline that person or make it seem like they're getting in trouble, because you don't want to discourage people who are sick or who are living with or in the same household with an exposed person from coming in thinking, oh my gosh, if I take a day off to figure this out or to take care of my family member, now I'm going to get fired. So I'm just going to come in. If you just come in and you're sick and it's this really communicable disease where you're going to have some other exposures, legal exposures and cost exposures that we'll talk about in a few minutes. So it may be that you don't really want to discourage that person from taking some time off, even if they're a really valued asset to the company.
I'm going to circle back.
Go ahead, Erin.
I have another private question here, which deals with employees who are paid on a commission basis. So if those employees are working from home, what is the employer's obligation to pay those employees? And so right now, I'm going to defer you back to that New York State law. Generally, some employers won't have any obligation to pay employees. Some employers will in the event of certain thresholds being satisfied. So you're going to have to take a look at that. But in terms of just straight commission for work performed, if that work is not being performed, I suspect that commissions will not need to be paid, but a base wage may need to be, depending on whether the new New York law applies to you.
Yeah, I'd also mention that brings up another point, that all of these different companies have, it's such a unique structure to every company. Some people have commissioned employees, some people have hourly employees, salaried employees, or a combination of both. And so adapting your policies or coming up with temporary policies is really going to be specific to your company.
And I loved another private question I've gotten from a trusted colleague in the law biz, as it were, is how do we lead as opposed to just being bosses, right? How do we help those we've sent home to telecommute do their job, be healthy mentally and emotionally, and continue to feel like a valued and trusted member of, you know, our team, whatever team it might be. And that's such an amazingly great question. I think that what we'll do, and thank you so much for it, we'll put together some resources and we'll get those out later on this week. I think all of us are considering how to do that best. I know I happen to work and volunteer with an organization called NABO, the National Association of Women Business Owners. Those of you who know me know that it's a passion of mine. And we're doing a webinar tomorrow on this very topic. So I will take what I learned there and share it with all of you in our community, because it is a challenge. So another issue that we're seeing, and I'm seeing in the chat, people telling us of other workforces where a diagnosis has been identified, right? That is expected to continue for some period of time, of course. But what do you do as managers, as human resources professionals, as owners of businesses? What do you do when you learn one of your people, one of your employees, or a family member of an employee has been diagnosed? So your absolute, without question, obligation is to alert your workforce that there has been a diagnosis among your team, but your equal and very important obligation is to not identify who that is. So you need to share from a public health perspective that there's been a diagnosis, and it could be, right? Let's think practically about this. If you're a retail establishment and you learn that a customer or a client has been diagnosed. So anytime you learn of somebody who has had access to your people, or your people have had access to, it's important to let your workforce know about that so that they can arm themselves with taking the precautions or taking the testing protocols that they feel are important to them. By the same token, of course, we've got to maintain privacy among our workforces. And for those of you on this call, I'm seeing some of you who are in healthcare, of course, y'all know about that from your day-to-day life. But even those of us who aren't involved in healthcare owe a duty of confidentiality and privacy to our employees.
On that point, I would just suggest to the extent that we're obtaining healthcare information about our employees, it be maintained like our employee health files, not in a personnel file, not in the employee's work file, right? So we just want to make sure that it is separate and maintained privately and confidentially. Even though it's not technically protected health information covered by HIPAA, it still is private information that should be separately maintained like an employee health file.
Lisa, I'm hearing the question a lot from employers. What if an employer wants to take an employee's temperature when they report to work?
Right. I think all of us have fielded that question over the last couple of weeks. And generally speaking, that is something that we would counsel clients to not do, because there are certain restrictions around mandated or mandatory health examinations, and that could fall into the category of a mandated health examination. Given the notion of the pandemic, it may in fact be an appropriate step to take as an employer, but there are so many variables to this question, and I'm afraid I've got to sound like a lawyer here and say it depends on the circumstances. So get some good legal advice around that before you institute the policy, because you may be able, in fact, to do it. And also, whatever policy you're permitted to put into place, it's got to be even-handedly applied, meaning you can't just test or take the temperature of one category of employees or one gender or one national origin. Hopefully we all know that by now, but we are seeing a fair bit of what I would categorize as discrimination or certainly ugly behavior towards some members of certain nationalities and national origins. And so we as business owners and managers never want to be in a position of conducting ourselves in a way that would create liability and would call into questions laws of discrimination.
And that's for sure for the wrong reason, right? We've seen people using some phrases to describe the virus that are inappropriate. We all know, I hope, everyone on this call would never do anything like that. But some people are also trying to do things for the right reason, right? They see somebody, they have an elderly employee, somebody who's over 70, they have a pregnant employee, but those are all protected classes too. So just singling out employees that have a particular, are of a particular age group or that we think might be more susceptible, a patient who has like a known history of cancer, for sure might be immunocompromised, and you might want to provide even additional protections for the right reason to that person. But we can't single out employees or groups of employees. We need to apply these policies and practices across the board.
So I'm going to switch gears a little bit because I'm also seeing in our chat box a question about the need to lay off employees given certain businesses are required to shut down depending on the industry. Lisa, can you tell us a little bit about layoffs and how that interacts with an employee's ability to get unemployment benefits?
Sure. Generally speaking, when you lay off or you separate even for a short period of time, and seasonal employers know this very well, your employees are entitled to collect unemployment benefits. We saw the New York State unemployment insurance website crash on Monday because there was such a huge uptick or swell in individuals applying for unemployment. They will be entitled to unemployment. The good news for our employees who we treasure and we don't want to run into hardship is that the state is waiving the 7-day waiting period for unemployment. The application process is a straightforward one. It's all online. Employees can, the moment, the day that they're laid off, can go on to the state website and seek those unemployment benefits. So throughout the crisis, that's at least some good news. Unemployment doesn't compensate employees at 100% of their rate. It looks to a quarter of their earnings and does some averaging and maxes out at certain levels, kind of goes beyond the content of this conversation today, but we're happy to answer and guide you through some of those questions offline if you'd like. The good news, though, in New York State is we have a robust unemployment program, and employees who are laid off will be entitled to that.
Depending on the length of that layoff too, employers might want to be mindful of deadlines about sending COBRA notices. And then new this morning, if you haven't heard already, it looks like New York State is reopening the ability for individuals to purchase health insurance on the state marketplace. So to the extent like we're trying to help employees as best we can through this, that might be a resource that is useful.
That is a great resource. I saw that just before we came on this call. That's huge, folks. So as most people, I think, know who are in the human resources arena or the benefits arena, and I know some of you are on this webinar, COBRA health insurance is very expensive. So the laid off or the separated employee pays at 100% of the premium, but the state opening up the marketplace will allow probably, my guess is, tens of thousands of laid off employees to secure health insurance at a nominal cost because they won't be working. So that's just a brilliant change, I think, to help all of our community feel assured. That also extends, I understand, to sole proprietors. So even if you haven't been laid off, but maybe you're a small business owner and you've never been able to afford insurance, now is the opportunity to do that.
And I'm seeing the question in our chat box. So it's open to sole proprietors, but it's not limited to sole proprietors.
That's right. That's right. So great news on that front. And again, the crisis is so quickly moving that we as employers, as businesses, may see some changes even beyond today, of course, and we will do our level best to keep all of you updated and keep us all plugging forward as best we can under the circumstances. So I wanted to talk a little bit about contracts for a moment, if we could. We've talked a lot about our workforce, and we'll go back to our workforce before we close this down in about 10 minutes from now. But all of you who might have contracts with vendors, with suppliers, you may be contracted to others to provide goods, services, products, or whatever. This is the time when we lawyers say, as much as you don't want to read that tiny type on the back of the contract form, this is when it's time to do it. And what you're looking for here, among other things, of course, we lawyers love contracts. What you're looking for is a provision that is called force majeure. It's a French term, force, F-O-R-C-E, and majeure is M-A-J-E-U-R-E. And it typically is written just like that. That might be the heading on the provision. In a nutshell, in human being speak, what that provision says is the party, either one of them to the contract, is forgiven from having to perform in the event of certain conditions. And you see force majeure clauses talk about emergencies. You see them talk about weather-related conditions. In the force majeure clauses we're drafting for clients, we're including pandemic. It's not typically one of the events we've seen before, although a pandemic can fall into some broad categories as well. My point in saying this is not to belabor it, but simply to say this is the time to look at contracts to see if you need to be forgiven of your obligation to perform, because you just can't do it for some reason. Or if your supplier, your vendor, your contractor comes to you and says, I can't perform, they may be able to trigger, or you may be able to trigger that provision. It's one of those contract terms that can help you and it can hurt you, but you don't know about it unless you actually read the parts of the contracts that aren't sexy, right? Sexy are the terms like, price and quantity and delivery date. we get that. It's sexy for us too, but these other sort of legalese provisions may come into play now.
Lisa's a lot more interested in contracts than I am, so I have to say this is not applicable to every lawyer. I don't think any part of a contract is sexy, but that said, it really is important to have a lawyer look them over, to have a lawyer be able to argue about that language and hopefully craft it in a way that benefits you and your company. When you're writing them now going forward, because you might be providing services really specific to the timing right now, but also getting out of contracts or making your vendors or suppliers or the people you're contracting with comply with an existing agreement. So it really is worth having a lawyer take a look at those contracts.
Absolutely. Hey, Jen, what other sorts of things should employers be looking at by way of policies, procedures, programs? Give us in a nutshell the kinds of things that look like they're going to be really important in the next little while.
Yeah, so we can look to implementing some temporary policies, as well as modifying existing policies based on what we know now. I mean, the world sort of really changed with this, right? So we're learning some things that we didn't really anticipate when we were writing agreements or writing policies, but also there are some things we can do right now in terms of temporary policies. And one of the greatest things, we had an awesome client write to us and ask about providing additional sick leave and PTO because they wanted their employees to feel safe and comfortable and supported financially. We understand not everyone can do that, but the response after we crafted that policy was how great they felt and how rewarding it was to communicate to their employees that they were going to be able to not come into work and still not have to worry about getting paid. That went a long way in terms of employee morale. And again, we understand that is not possible for every single employer. You have to make them specific to your workforce. But a temporary policy allowing employees to do remote work. A lot of us have not been fans of remote work for ourselves or our employees, but there really are meaningful things people can do remotely. Putting in a policy is going to be really important so that we're ensuring, one, we're following wage and hour laws, that we're sure that the employee is reporting back when the exact hours he or she is working, that they're working securely, as we talked about before, following any of the sort of rules that our company has in place. And for those of us who deal with confidential information, protect health information, they're going to be a lot more significant. You may want to institute additional policies regarding cleaning, not sharing things like your phone and your computer and not touching the same things as your coworkers. We talked about staggered shifts. You can talk about permitting people to take unpaid leave and still maintaining their job, or using their PTO, maybe relaxing your PTO policy if you had a policy about how much advance notice someone needs to give to use PTO, maybe relaxing that a little bit so people feel comfortable not coming in if they're sick. You may want additional security policies, crisis management, media response. Lisa mentioned, what can we as lawyers do, but what can also CEOs do? You can be leaders right now, right? You can demonstrate that you are taking your customers seriously, you care about their health, your employees, and you can have a communication policy that really helps you. And then other sort of business and contingency plans, business continuation plans.
Great points, Jen. We're hearing a lot about that. We're, of course, as a business, putting some of those in place for ourselves as well, and we're hoping that we can get these done very quickly as people need them, because we're all involved in this very changeable and fast-moving situation. One of the things that some of our clients are concerned about is, generally speaking, their liability if they continue to have their employees at their work sites, whatever it might be, and somebody gets infected from a coworker or somebody who visits their office or their job location. What do we think happens there, Jen?
Yeah, so taking this in a couple of different categories, COVID's really, it's unparalleled. We don't have anything to go back to and compare it to from a sort of general negligence perspective. So if we're talking about customers or invitees and you have an employee who gets someone sick, well, are you going to be liable? I think it's going to be analyzed like a general negligence case was. You know, the duty, the breach, foreseeability, causation, damages. The argument's going to come in probably on breach, right? So if we are following good guidance and implementing the right policies and procedures, we're being fully transparent with our workforce and our customers and doing all the right things. That's why I'm sure you all have gotten millions of emails from every vendor you've ever bought for, from, you know, Macy's down to the restaurant down the street. Everybody's sending out emails about what they're doing from a cleanliness perspective. I think those things are helpful if they're crafted correctly, because now you're going to have to live by some of those statements. But taking those correct steps is going to be helpful, and putting in the right policies and procedures. And that goes back to the screening employees, making sure employees don't come to work sick. The second category is employee to employee, or the workers' comp potential claims. And there, I think that there is some exposure. If we know that somebody at the office infects a coworker, that coworker is going to have a workers' comp claim. I think that that's pretty clear. That's also probably OSHA reportable, and it's not necessarily reportable if an employee just comes in and said, "I think I was exposed at work." But if they have some evidence that a coworker came in sick, got them sick, it may be OSHA reportable. Then the next step is, does the coworker's family member have a negligence claim against the employer? And again, if we put in the right policies and procedures, we're going to have the best argument that there should not be liability from a general negligence perspective. And the final thing to consider is sort of the employment law and discrimination components. And that's, you know, we've heard some, as Lisa mentioned earlier, some really ugly phrases being used about this disease, where it came from, how people are referring to it. If employers learn about those sorts of comments being made, they need to put an end to it immediately. That is for sure. You can't allow that to exist.
Good point, Jen. Like any other conduct that raises the specter of discrimination, even in crisis times, right? We're obligated as employers and as responsible stewards of our community to not fall into that sort of banter. Sometimes we hear folks say, you know, well, I was just joking about it. New York law is not going to permit that. It is a state that protects employees very broadly, and we all, as employers and managers and those who are stewarding our workforces, have to be sure we're keeping our policies in the front of our mind, even with respect to that, and even in the context of a crisis. So I'm seeing a couple of questions and comments. I have a comment from my good friend Larry, who mentioned that it might be better for a business when it does its economic analysis to try to provide PTO benefits versus having employees apply for unemployment. That is a very business specific issue. Has some implications as well from the perspective of notifications. And of course, a business won't necessarily know how long this process may be facing us. So that's a great idea to consider, but we would suggest that it be done in consultation with your benefits experts, right? Those who guide you on those sorts of issues. So we've come to the end of our 40 minutes. We promised ourselves, and we thought we should promise all of our guests that we would go 30 minutes plus 10 for Q&A, and we wanted to sort of have the Q&A be part of our discussion when it was relevant. So we want to thank all of you for being here. Jen's put our email addresses in the chat box. We also are going to embody what we've talked about here in a COVID-19 guide. We have a Google Sheet. Erin knows more about this stuff than I do, where you can input your information if you'd like to get it. Anything you want to say about that, Erin? Oop, hang on.
Here I am. Sorry about that.
It's
I've got
okay.
this on a sheet of paper. If you can't see the chat box, we tried to make the link as short as possible. I'm just going to hold this up for a couple of seconds so that you
Click
can
on Erin's name so that she's in the big center box if anybody needs to see that up close.
And I've also put it in the chat window, but I just want to make sure everyone has access to this link. It's just a form that allows us to collect your email address. We're not sharing it with anyone. It just allows us to keep track of who wants this guidance that we're putting out, and we'll go ahead and email it to you in the next couple of days.
And just so that it's easy for everyone, we will also put this URL on our Facebook page, the Coppola Firm. I know as a technologically challenged individual, I can't always write that stuff down as quickly as I should be able to do. So we'll make sure that it's out there for you if you wish to have this information from us. If you want to shoot us an email, we're always happy to respond to you very quickly. We think it's part of our obligation to our community. We are all at our firm repeating daily that we are all in this together. And when we say that, we not only mean the lawyers and the staff at the Coppola Firm, but we mean all of you. We mean our community. Many of us have colleagues, friends, family members, clients across the country and across the world. This is one of those moments where we are joining together, and we will give as much as we possibly can to share with you our insights and provide you with some good practical guidance you may be able to put in place for your own businesses. So with that, we've concluded this webinar. Thank you again for visiting with us. We will have more on this topic in the coming days and weeks, of course. To Jennifer Scharf and Erin Ewell, have I forgotten something?
Nope.
I think we've covered everything.
Okay. And to all of you on this meeting, thanks so much for joining us. Don't ever hesitate to reach out. Be well, and we'll see you soon.
Thank you.